You people took my what?
Fucking tarp.
You said it's weak. It's probably not going to stick, but it's the only way I can get them to shut up.
You're probably 100% right.
So the people are confessing a Rule 16 violation. By Judge Swan's ruling in People v. Gruel on July 13th, this pattern of discovery violations has continued under Jeff Lindsay's leadership. Are we ready on Ms. Van Haverbeek? Yes. Yes. Are we ready?
Yes, ma'am.
Okay. 25M 754, Ms. Van Haverbeek, come on up. All right. We are scheduled for a motions hearing. The original motions filed related to the defense filed motion to suppress statements and a motion, the way that they got uploaded, there's a motion for violation of freedom of speech, and thereafter a second motion for violations of due process and Rule 16. Are the parties ready to proceed to hearing?
Ma'am.
All right. I'll note that just yesterday, the people filed a notice of intent to introduce 404B. We'll address that after we have heard the bulk of the motions hearing. I'm assuming that the parties aren't ready to address that fully today, but we can touch upon that after we have discussed the other motions.
People would call Jeff Canada.
All right. Come on up.
And how are you employed at the present time?
I'm employed with the Fountain Police Department as a corporal.
Certified peace officer?
Yes, for almost 12 years.
And before you went to work for Fountain, where did you work?
I worked for the Canyon City Police Department for 11 years.
Back in December 21st of 2025, were you on duty that day?
Yes, sir.
And did you make a call on family events of McGannaville?
Yes, a disturbance between two neighbors.
And could you tell the court what happened with all of that?
We had a series of events between these two neighbors over a several month period where we've had up close to 53 calls to service between these two. Most of the time, it was basically harassing in such a way to where there wasn't enough to charge, but it was getting borderline.
Who?
Most of the time, we would get a call from the 902 address claiming the neighbors were either violating her airspace with dryer sheets or something another. This recent one was regarding several things. One with a tarp allegedly being stolen with no proof. And then this neighbor was calling in because as they had walked by their side of the yard, she reached over, she threw water into their yard. Granted, he was a distance away, but she was still basically antagonizing the individual. And also the night before, she had basically yelled at the kids and using language that any parent that had grade school kids would have been angered and would have responded normally.
Do you remember what was said?
Something about you. I know you fucking people took my, excuse my language, took my.
And I'm sorry, I had coughed. You people took my what?
Effing tarp. I'm trying not to.
If it's a quote, you could say it. Thank you.
Yeah, fucking tarp. And I knew that there had been high winds just the previous days. So I had confirmed it with dispatch that we had high wind gusts. But at the same time, she could not provide any concrete proof that they took it.
So you said there had been something going on the night before.
Yeah. Apparently they have on video her yelling and cussing at the kids who were on the trampoline regarding her tarp missing.
Oh, I'm getting the name right. McGonigal, is that?
Vance.
He does have some video.
Yes.
And he did upload a couple of videos, one where there was water being thrown, and one where she's shining the light on the house.
Yeah, I forgot about that. Yes.
And you uploaded those to Axon.
Yes.
And we've taken a look at those today, and have they been altered in any manner?
No, they have not.
All right, for the purposes of this hearing, People's Exhibit 1 will be admitted. All right, now with that, let's begin with Exhibit 1.
You're fine. I can see.
There's really no audio on this. Officer Canada, the video that was presented did not have the language that had been used.
Yeah. So the one that Vance showed me, that one did have the language, but apparently he has not ever sent that through our community request. So I don't know how you guys want to proceed with that.
But that's what you saw, and
And that's what it was. That's what my summons was based on. That, and we've had 53 encounters at that point in time between the two of them, to the point that it was borderline harassing and stalking of the neighbor for no other reason than personal.
and so that's why you decided to file the harassment charge.
Yeah, the best one that fit was the taunts and challenges at the time because of the language, because any parent that had a grade school kid would have heard that language, would have been aggressive towards that individual. It'd have been different if it was a isolated incident, but this has been an ongoing thing.
All right, thank you, Jeff. Ask the witness.
Cross-examination for this witness. He had a video of Ms. Van Haverbeek yelling the night before.
Yes,
He showed you that video.
yes.
He sent that video to you.
He said he did, yes. He sent us several videos.
He sent you several videos.
Yeah, we have a thing called a community request. We basically get their email address through Axon. We send it to them. It gives them the ability to copy and paste.
If it's not done within a certain period of time, you could follow up.
Yes, I could, but with the calls to service, it was already filed at that point in time. It was out of sight, out of mind.
You've responded to these two parties 53 times.
Not me personally, the agency itself.
The agencies responded to these two parties 53 times.
Yes, according to dispatch, there have been 53 calls to service.
You're familiar with these parties.
Yes.
You would have been able to follow up.
If I had it on my mind at the time and I wasn't taking a call or supervising a shift.
On direct, we watched the video that Mr. McManigal sent.
Okay.
On that video, Ms. Van Haverbeek said, "Put the tarp back on my bikes that you stole last night."
Correct. That was the second video he had showed me.
She also said, "Want to do that."
I'm sorry.
She also said, "Want to do that." On that video.
Possibly, yes.
On that video, she does not say the word fuck.
Correct.
She does not say any curse words.
Yes, on that video, yes, you are correct.
You can't see anyone else present in that video.
No, you can hear the kids in the background.
You can't see them.
Yeah, I guess you would be correct in that.
Mr. McManigal sent you other videos as well.
Yes.
And on those videos, Ms. Van Haverbeek does not say anything.
No, she does not. She just throws water across into their yard.
While you were talking to Mr. McManigal, Ms. Van Haverbeek was talking to Officer Branham.
Yes.
She told him that the neighbors had stolen her truck.
Yes.
You then went over there and told her there had been strong gusts of wind over the past few days.
Yes.
You told her she was being charged.
Yes, for the one video he did show me where she did cuss at the kids.
And you told her she needed video proof for you to do anything about the tarp.
Yeah, because it was her word against his. Other than that, it would be he said, she said. That was the only reason why she was getting charged, because of the video at that time.
You wrote Ms. Van Haverbeek a summons.
Yes.
When you went over to give it to her, Officer Branham was reading Ms. Van Haverbeek her Miranda rights.
That I did not know until afterwards.
He asked if she wanted to make a statement.
Mm-hmm.
She said no.
Okay.
But Officer McGeaney kept talking to her.
Okay. I'm trying. I don't remember. But yeah, go ahead.
Officer McGeaney told Ms. Van Haverbeek about the number of calls she'd been involved in.
Okay.
She said it was ridiculous.
I can't answer for Officer McGeaney. I can only answer for what I took part in.
You were present during this conversation.
Okay. then I guess you are correct. To be honest, I don't recall. Okay.
You accused Ms. Van Haverbeek of digging through her neighbor's trash cans.
I actually witnessed that.
Is that a yes?
Yes.
Ms. Van Haverbeek denied this.
Yeah, she tried to, but she was also almost practically waist deep in their trash can.
During this conversation, responding to this call, you accused her of digging through her neighbor's trash cans.
No, that incident, and I'm sorry if I didn't clarify in my report, but that incident happened days prior.
It's your testimony that you did not talk to Ms. Van Haverbeek about digging through her neighbor's trash.
I yelled at her to get out of the neighbor's trash, and she flipped me off because I tried to tell her that it's not communal property. Basically, it's still private property, and it was technically up against the neighbor's fence in the alleyway.
You're telling this court that you did not talk to Ms. Van Haverbeek about digging through her neighbor's trash when you responded to the call.
I may have. Like I said, this is close to a year old. I do know I witnessed that days before.
You wore body cam.
Yes.
That body cam has video.
Yes, it does.
It has audio.
Yes, it does.
I'm now approaching opposing counsel with Officer Canada's body cam. We'll admit this as Defense Exhibit A. You're asking to admit Defense Exhibit A? Yes. Is there an objection? 1812 through 2015. All right. So when you provide that to me, please just have that snippet. Okay.
So I just want you to be aware of something. Since May of this year, you have been involved in 56 incidents between you and your neighbor alone. 56 times it's had to do with you and your neighbor. That is ridiculous. We have 1.5 million other things that we need to be doing right now. We're not dealing with this neighbor dispute where you two can't leave each other alone. You take his trash cans, you take his trash can, you carry water.
I've caught you twice digging through their trash cans. I even yelled at you one day when I was chasing a bad guy.
That's the one I'm referring to.
Stop and open their trash can, and I yelled at you. You flipped me off.
56 times we've been out here since May of 2025. I never done. Why? Because he's watched you.
I've watched you do it twice. I'm done with you. So here's the deal. Here's the deal. So you're getting charged today with harassment because you threw water over there. You've been cussing at them. So you're getting charged with harassment today. The court date is January 27th, 2026 at 1:30 in the afternoon at 136 Justice Center Road in Canyon City, Colorado, the Fremont County Combined Courts. This signature is just saying that you promised to be there on your court date.
The call out here. We know my shift. It's another call out here. I'm coming out here. Yeah.
That's all. I never once agreed to any of that.
That's there. I come out here for you to going back and forth. And if I find evidence that you're doing what you're doing right now, throwing water and harassing them and things like that,
Taking on the fence.
Jail. Do you understand? Do you understand?
So yes or no question.
That's what I need you to answer right now. Do you understand?
No, because I took the map about the water. I'm sorry.
We've already established that that's not true because we watched the video. So
I know.
Okay.
All right. Have a seat, ma'am. Thank you.
Yeah, he did at the very end.
You and Officer McGinney accused her of lying.
Okay. Yeah, in the video, Officer McGinney says that, but when we were questioning her, we were not questioning her about the summons that I was citing her for. We were talking about a previous incident in which she wasn't cited.
Officer McGinney said that if she or anybody on her shift got another call, Ms. Van Haverbeek would go to jail.
That's according to Officer McGinney.
No one besides you and the other officers were present when talking to Ms. Van Haverbeek.
We were there. It's just no one responded to follow up on her.
Yeah, at this incident, it was just
Ms. Van Haverbeek, and the 4 officers.
Yes.
When you responded, you were in your uniform.
Yes.
That uniform includes a vest
Yes.
with a patch that says police on it.
Yes, ma'am.
Your uniform includes a handcuff pouch
Yes.
and a,
Well, actually, my uniform does. My belt.
and a taser
Yes.
and a firearm.
Yes.
You responded to the scene in your patrol car.
Yes.
3 other officers responded as well.
Yes.
After your interaction with Ms. Van Haverbeek, you went back to your patrol car.
Yes. That to write the summons.
After you had served,
Oh, after I served her. Yeah, I went back to my car.
you were alone in the car.
Yeah.
You're not talking to anyone.
I don't know. I may have been talking to myself and not turned it off. That sometimes happens.
You weren't on the phone.
Honestly, I don't remember. I don't no longer have access to that camera because I'm no longer with the agency. So I have not had the ability to review my footage prior to the court.
Understood. You said it's weak. It's probably not going to stick, but it's the only way I can get them to shut up.
You're probably 100% right.
You said that Mr. McManigal showed you a video.
Yes.
That video was not the same as the video you saw today.
Yes, you are correct.
On that video,
She does not meet the element. You are correct.
on that video, she's alleged to have said things like, "Give me my fucking tarp back."
Not in the video we watched.
In the video, you said Mr. McManigal showed you.
Yes, the one he showed me.
In that video, she's alleged to have said things like, "Give me my fucking tarp back."
Yeah.
Nothing further.
Any redirect for this witness?
Yes, Your Honor. Officer candidate, did you ever put Ms. Van Haverbeek into custody?
No.
Ever tell her she was under arrest?
No.
Ever take her to your, put wrist restraints and put her in your vehicle?
No, I did not.
So this was all out in front of her house.
Yes.
She was free to leave at any time.
Yes, I guess.
Wanted to go back inside the house, she could have,
Yeah, that we wouldn't have been able to stop her. No.
but she didn't do that.
No, she didn't. She talked with us.
Are the people intending to call any other witnesses?
No, Your Honor.
Is the defense intending to call any witnesses? No. All right. As to the freedom of speech and motion to suppress, any arguments?
Right to free speech includes protection of distasteful and vulgar language. Courts have recognized a handful of categories of unprotected speech that present such a danger. None of these categories are applicable to Ms. Van Haverbeek's alleged statements. Rather, Officer Canada's annoyance was the only reason Ms. Van Haverbeek was arrested. One of these categories of unprotected speech is true threats. Ms. Van Haverbeek's words did not include any statement of intent to commit an act, let alone an act of unlawful violence as to the particular individual or group of individuals. Even if she had said, "Give me my fucking tarp back," or something like that, that is still protected. As for fighting words are words which have a direct tendency to cause acts of violence by the persons to whom individual the words are addressed. For example, in People v. Hughes, the court explained that the use of the words whore and bitch fell short of the threshold for fighting words because they would not induce an immediate and violent response from the average person. By contrast, Ms. Van Haverbeek's statements are extraordinarily mild. They do not constitute fighting words. Ms. Van Haverbeek's speech is thus protected and she cannot be prosecuted for it. So the charges must be dismissed.
Mr. Tommy, do you wish to be heard as to the statement's motion?
You know my argument about that, Judge.
I don't yet.
I mean, she's out there at night shining lights on their house, talking to them while they're in the house, not leaving them alone, throwing water in their yard, throwing water at him. It's the manner in which it's being done. And that's the problem we have with this case and we have with Ms. Van Haverbeek, is she just will not leave the McGonagalls alone. And so that's why we're pursuing the charges. And while she may have a free speech to do that, I think the manner in which she's doing it is key to all this and how it's handled, and just the repeated use and the repeated call out of police officers or such, that it should not be dismissed and it should not stand.
Thank you. It's your motion and your rebuttal.
Your Honor, to be clear, these charges are based on the statements that were made that day. They have not brought charges regarding her other alleged incidents with law enforcement. So while that context has to be considered, the prosecution is not for the broader context. It is for the statements made that day.
Which was reported through testimony as, quote, "I know you fucking people took my fucking tarp." The court notes that when we are talking about violations of the law as compared with freedom of speech, in order to prosecute an individual for the content of their speech, I'll note that this is not a content neutral statute, but a specifically content driven statute. The content of that speech must fall within one of the recognized exceptions to the First Amendment and or the Colorado corollary. Court has not heard that the people are arguing that this was a true threat. I haven't heard that argument. The court doesn't find that this could be construed as a true threat. The statement not including any act or threat to act violently or otherwise. The remaining contention relates to whether or not this is fighting words and whether it falls into a fighting words exception. Again, that is repeatedly insults, taunts, challenges, or makes communications in offensively coarse language to another, and the portion that allows it, at least on its face, to survive constitutional challenge is in a manner likely to provoke a violent or disorderly response. That is the provision that relates directly to the fighting words exception. The court recognizes that the fighting words exception is exceedingly narrow and ever decreasing in scope. There is a distinction between the words that we have here and the words that might have a direct tendency to cause an act of violence by the persons to whom individually the words are addressed. Here in the context, the words were addressed apparently to children. The court doesn't have more information as to any of the characteristics of these children. What I did hear was that in Officer Canada's opinion, that a parent of a grade school age child would be offended by that language. I don't know that these children are grade school age children. No one has presented that evidence or testimony to the court. Freedom of speech provisions protect speech that is offensive, coarse, protects speech that, while offensive, while coarse, while distasteful, such speech is protected by the First Amendment. The court notes that this is a similar instance to, I want to say it was Chemerinsky, is that the right? The famous case from, I want to say the 70s, where an individual was wearing a jacket that said, quote, "fuck the draft." And that speech was protected by the Constitution. The court notes that this is slightly different than that. This was language directed towards an individual, not political commentary, if you will. But the court does believe that under the prevailing case law, the statement of Ms. Van Haverbeek in particular is protected speech, protected by both the United States and Colorado constitutions. To the extent that the people are seeking that theory of prosecution, that would be unconstitutional. Now, I can't wholesale dismiss the matter because the people have indicated that there were two potential pieces to the theory of prosecution, one being the statement and the other being the throwing of water. There is a count 2, which is disorderly conduct. The disorderly conduct is a content neutral provision, not one that is seeking to penalize Ms. Van Haverbeek for the content of her speech. It is the unreasonable noise provision. So this court's ruling does not apply to that particular statute. Does anyone want to be heard as to that?
I do believe it would be a violation of Ms. Van Haverbeek's free speech rights under the Colorado and federal constitutions if she's prosecuted, if the theory of prosecution for that charge is based on the content.
And so again, I'm not going to go so far as to make any additional rulings in relation to the disorderly conduct, which was only added yesterday, and not the substance of the motion or the hearing. Anything further on the court's ruling on harassment?
No, Your Honor.
All right. Now, I heard the people make an argument in relation to the Miranda, but I didn't hear any argument in relation to the Miranda from the defense. Did you want to make any additional argument on that?
Yes, Your Honor. When a suspect is subjected to a custodial interrogation, they must be read their Miranda rights. Interrogation is questioning or its functional equivalent, and that includes statements reasonably likely to elicit an incriminating response. We did not hear from the officers who primarily interacted with her, Officer Branham and Officer McGeaney. I would note that this is the people's burden to disprove that her Miranda rights were violated. Additionally, custody is not limited to being placed under arrest, but rather it's any time a suspect is deprived of his freedom of action in any significant way. In this case, 4 armed and uniformed officers responded in marked patrol cars. She was not free to leave, which restrained her freedom of action, and she was accused of lying about her neighbors and her conduct. No one was present besides her and these officers, and she was not read Miranda rights until midway through the interaction. Additionally, statements made after Ms. Van Haverbeek invoked her rights should be suppressed. Questioning must stop after an invocation of Miranda rights. Invocation of rights must be scrupulously honored, or else any statements obtained must be suppressed. Ms. Van Haverbeek clearly invoked her rights after Officer Branham asked her if she wanted to make a statement. She said no, but officers continued to talk to her and question her. Officer McGeaney continued to speak to Ms. Van Haverbeek and make accusations of lying and false reporting. Accusations like this made directly to a person are likely to elicit an incriminating response. Finally, defendant's statements are only admissible if they were made voluntarily. She was in custody. She had no opportunity to confer with counsel. No one else was present. Additionally, Officer McGeaney threatened to take her to jail. Ms. Van Haverbeek was upset over the accusations her neighbors were making and upset about not being believed by officers, putting her in a vulnerable mental state. Statements made due to continued interrogation after the invocation of rights are presumed to be involuntary and inadmissible. This is the case here.
May I respond?
Yes.
The police have been called out there anywhere from 53 to 56 times in 2025. Ms. Van Haverbeek is not surprised by police officers because she's called officers a lot. So even though they show up and they have their handcuffs and their guns and the lights are going or whatever, she still keeps calling. So people's position is she's not particularly intimidated by the police. They read her Miranda rights because that's kind of what everybody does, which is always a good thing. Mainly, and listening to what the video they played, they were chewing her out for calling all the time, and they were tired of coming out there, and they weren't asking her questions about the event for what they were there for. They just were sick and tired of going out there and dealing with this mess. She was not intimidated by the police judge, and it was not a custodial interrogation. We asked you to deny any suppression, and really she didn't say anything, to tell you the truth, but deny any statements that she supposedly made.
Thank you. There is no evidence in the record that there are 2 parts to this, that there has been simply no questioning, no evidence at all. So the court doesn't weigh in as to any statements, real or testify. I just have no evidence to support anything prior to the invocation of Miranda. That piece is contained in Defense Exhibit A, but there was no questioning of the witness and no testimony of the witness as to any statements made by or to Ms. Van Haverbeek, any questions asked of her prior to giving Miranda. The court notes that there is evidence to support that Miranda was given. There is also evidence to support that Ms. Van Haverbeek elected unequivocally her right to remain silent. She was specifically asked after the conclusion of the giving of Miranda, do you wish to make a statement? To which she unequivocally stated no. The court notes that subsequent to that, the law enforcement officers, of which there were 4 that the court could observe on the video, did continue to engage in generously, I'll call it a conversation. We'll get into that more in a moment, a conversation with Ms. Van Haverbeek. The tone of that conversation, I'll say, was not conversational. There was, and I think there has been testimony to support the fact that law enforcement officers were incredibly frustrated at Ms. Van Haverbeek, and the tone of the conversation clearly reflected that. When we are talking about interrogation, it is not simply whether she was asked questions, but whether there was conversation or statements made that are likely to provoke an incriminating response or to elicit an incriminating response. Statements made, because at first they were statements that the court observed in Defense Exhibit 3 included statements coming from Officer McGeaney about, since May of this year, there have been 56 calls for service. This is ridiculous. We have a million other things that we could or should be doing, et cetera. And then Officer Canada began, and again, in a manner that was not a calm demeanor, somewhat yelling at Ms. Van Haverbeek, pointing a finger at her as he was yelling, that the court could observe on a video for emphasis, and pointing at her while law enforcement officers, I think it was Officer McGeaney, did make statements of that she had been, I don't know if she used the word lying, but that's not true, as Ms. Van Haverbeek tried to make statements about digging through the trash. And ultimately, there were statements about the throwing of the water and cursing at them. Now, Officer Canada did stop Ms. Van Haverbeek from making additional statements. I think held up a hand in the video and began talking to her about the summons that she was going to receive. And then there were certain threats, if you will, coming from Officer McGeaney. Now, they were equivocal. They were conditional. If I get another call out here, I am personally taking you to jail. I believe that she then backtracked about, if there's sufficient evidence to support that. But this was not a conversation. It was not calm. The testimony from Officer Canada was that they were frustrated, and that is very clear. That frustration came through in their voices, their demeanor, their body language, and the words that they used. The court does find that those statements were made in a manner likely to provoke an incriminating response. They were admonishing Ms. Van Haverbeek about what they perceived to be her behavior over a period of months. And the court recognizes that frustration. The court's not trying to weigh in as to whether that was warranted or not. However, when a law enforcement officer is engaging with a defendant in this way, after they have validly invoked their right to silence, it is in a manner likely to elicit an incriminating response. To the extent that it didn't elicit that, it's relatively unclear. The court would have to listen more closely to the statements. I think Ms. Van Haverbeek does make some statements about throwing the water, which could or could not be used if they were ultimately admitted as to impeach her credibility, et cetera. But certainly they were made in a manner that was likely to invoke an incriminating response. The touchstone remains as to whether or not she was in custody at that time. She certainly wasn't under formal arrest. While there's mention in the motion filed by the defense that she had been told she wasn't free to leave, there's no evidence in the record as to whether or not that occurred. The testimony from Officer Canada was that she was free to leave, although he did say that with what the court observed as some hesitation. The test is whether a reasonable person in the suspect's position would believe himself to be deprived of his freedom of action to the degree associated with a formal arrest. The court notes that when this interaction was occurring, Ms. Van Haverbeek was seated on the stoop of her home. There were four law enforcement officers around her in a semicircle. They were uniformed. They had, as I think the testimony supported, all of their standard duty items, tasers. There wasn't direct testimony as to firearms, but handcuffs, et cetera. Officers obviously had their uniforms, badges, all of those standard uniform pieces. They were within couple of feet of her. They were not unduly close up in her face necessarily. The words spoken, the demeanor, the length and mood of this, while it wasn't a significantly long deprivation of any freedom of movement, the words spoken, the demeanor, all of that does weigh in favor of a custodial situation. This was a relatively aggressive circumstance. Comparatively, again, the officers were frustrated. The officers were pointing fingers and somewhat yelling at Ms. Van Haverbeek, and doing so in direct relation to her conduct. So I do find that from the moment that Ms. Van Haverbeek stated no, she does not want to make any statements, that the statements made her right to remain silent, that she properly invoked that right to remain silent, that was not scrupulously honored. And so any statements following her saying no, she doesn't want to make a statement, are suppressed. All right, there was a Rule 16 motion filed. Did you want to be heard on that?
Yes, Your Honor. The violation here is the late disclosure of Officer Branham's body-worn camera footage. Rule 16 1A18 requires the prosecution to provide statements of the accused to the defense. Officer Branham was the first officer to talk to Ms. Van Haverbeek, and the whole video is essentially of him talking to her. Additionally, Rule 16 1B1 requires that this is done as soon as practicable, but no later than 21 days after the defendant's first appearance at the time of or following the filing of charges. The charges were filed on December 23rd, 2025, and her first appearance was entered on January 27th, 2026. She entered her appearance the next day as well and filed a motion requesting all discovery in compliance with Rule 16. The defense did not receive this footage until June 5th. This is 130 days after Ms. Van Haverbeek's first appearance following the filing of charges, so this is a violation.
Sorry, you received it on what day?
We received the footage on June 5th.
June 5th. Okay, thank you. You continue.
Additionally, in People v. Lee, the court held that a deterrent sanction is appropriate when there's willful misconduct or a pattern of neglect, demonstrating a need for modification in discovery practices. Exclusion of evidence can be punitive or deterrent as opposed to curative, and this is supported when there's a willful misconduct or a pattern, as long as the court makes a record of that misconduct or pattern. In this case, the reason for the delay is negligence. There's been an indication that Officer Branham's body-worn camera wasn't connected to this case number. No one looked at the case closely enough to realize this issue until the defense pointed it out. It's clear that Officer Branham was present on the other officer's body-worn camera, and his body-worn camera is referenced in Officer Canada's report. Regarding pattern and practice, some courts have noted that a pattern of violations can consist of as few as 3 violations. There are many more than 3 violations in this pattern. I'm aware of over 15 violations found in the 11th Judicial District this year. A pattern is overarching and not in regards to a specific type of discovery violation. The Supreme Court explicitly rejected that narrow definition in People v. Whiteside. In the past, the people have been afforded some grace under the belief that these widespread discovery violations were a result of Linda Stanley's leadership. However, as demonstrated by Judge Swan's ruling in People v. Gruel on July 13th, this pattern of discovery violations has continued under Jeff Lindsay's leadership. Furthermore, not only is there a pattern of discovery violations in the 11th Judicial District, this is the second discovery violation in this case. It's clear that a pattern and practice of negligence in discovery violations still exists, and that's evidenced by this case. There's no reason why these items were not provided to the defense within the required time frame. Accordingly, dismissal is appropriate in this case as a sanction for violating Rule 16. There's a need to deter this conduct, and it's clear that lesser sanctions are not effective in doing so. Ms. Van Haverbeek makes this request pursuant to her rights under the 5th, 6th, and 14th Amendments of the United States Constitution and Article 2, Sections 16 and 25 of the Colorado Constitution.
Thank you. Mr. Tommy.
Honor, as far as the body-worn camera, excuse me, forgot my water. As Ms. Stickler pointed out, as we discovered, once when they filed that and we looked at it, what had happened is we contacted Kansas City Police Department. Officer Branham's body-worn camera that day was assigned the wrong Kansas City Police Department number. It was for another case. It was not for this particular case. So when we found out, we contacted them. They did look through and they looked at it on June 4th. They found it. They corrected the number. They sent it to us and we discovered everything on June 5th. So as soon as we found out, we discovered that. We've endorsed all the witnesses. There is no prejudice. They've had the video for nearly 2 months at this point. We got it corrected and we got it sent.
So the people are confessing a Rule 16 violation.
We're saying we're late in sending it because we didn't get it like we should have.
Which is a violation of Rule 16.
Yes, ma'am.
And would you agree that that is not the first time, even in this case, that there has been a Rule 16 violation?
Well, our position is that, yes, mistakes were made. We did correct them and that there's no prejudice, Judge.
And the case law cautions the court to consider other steps that the people may have made subsequent to learning of this and other Rule 16 issues, in particular in this case? Have there been any training modifications or outreach to the CCPD to prevent this type of thing from happening ad nauseum?
As far as the endorsement of witnesses, yes, ma'am, we have corrected that. As you have mentioned before in these types of cases, that you have noticed that the endorsement of witnesses have been occurring. And so we have corrected that part of it. Kansas City PD has found out about this. We're trying to work with all the law enforcement agencies. Mr. Lindsay is working with that and working with them and trying to get everything set up so we can be even better at doing the discovery. So yes, there are things being put in place to take care of that. So
do you know specifically what has happened within your office to remedy this issue?
As far as the endorsement of witnesses?
No. As far as getting evidence properly labeled within the agencies. I've heard a lot of, the agency made an error, it wasn't our fault, and we fixed it in the past 6 months. And that's not necessarily unique to the CCPD, but as the agency that is required to ensure the timely flow of information, it becomes your problem. So what has happened to correct the issue?
I don't know specifically, but I know Mr. Lindsay has been working diligently and trying to correct these things and talking with the different agencies and trying to get all that straightened out, trying to get them to put things in place to make sure we have everything done. What specifically, I don't know. I have not been made privy to that, Mr. Lindsay. Looking for something, for some reason I can't find it.
Well, that's something that's obviously critical to the court's consideration as to what sanction to impose. The people also late filed a motion yesterday. I'm not clear as to why the court should allow it, inconsistent with the court's pretrial order. Do you want to be heard on that piece?
I'm not as perfect as I would like to be or up to date as I would like to be. People get behind. This case is set for trial, and trying to get ready for trial is something I've believed that that we should file to help prove our case. And yes, it was after the notice, and that's obviously on me, but it was trying to put the prosecution in a better position to prove the case by beyond a reasonable doubt. So we're asking the court for give a chance for the hearing on that and to move forward.
We would ask the court to summarily deny the motion. That is what's stated in the court's pretrial order, that motions, substantive case dispositive motions that are filed untimely will be summarily denied without good cause for the delay. I don't think getting behind on the calendar is good cause. I'm sympathetic to the fact that we all in this courtroom have a lot of cases to deal with and a lot of things to stay on top of. But this is something I have heard from the district attorneys in this courtroom multiple times, that they are not seriously looking at their cases until we're approaching a motions hearing or trial. And that is unfair and unconstitutional for clients like Ms. Van Haverbeek when we are coming up on less than a month before trial and things in the case are changing.
The court notes that the specific language in the pretrial order identifies 404B motions by name as being required to be filed within 21 days of the date that the not guilty enters. The court notes that the law as it relates to requirements on the people and defendants is not always identical. In particular, there are often occasions where the defense late files motions, but they are constitutional motions that have to be heard as the risk of being overturned on appeal, which is not the same as a 404B motion. I recognize that that places the parties on unequal footing. This court did not make the law. The court, in making a ruling, does not seek to be unsympathetic to the issues of the parties, but the 404B motion attempts to alter the status quo by increasing the amount of evidence in a case and requiring the defense to defend against additional acts uncharged and not previously planned for. To do so this late in the case, I show that we're set for trial at the time of the filing of the motion, 23 days from the filing of the motion. The court is going to deny the motion for 404B as untimely. I am not and have not received sufficient information for the court to rule on the Rule 16 motion. I'm going to set this for the people to provide the court with information specifically about the acts that have been taken to prevent similar body-worn camera issues. I see, since the court began making a record of Rule 16 violations in this case, which is the court's own work product and not something that the parties are privy to, that there have been at least 6 Rule 16 violations for the late providing or the never providing of body-worn camera. Looks like that's within about 2.5 years from today going back. So 6 within that period of time. So I am very interested to hear what steps the people have been taking. I would have wished to have heard that today. I'm going to set this for the people to provide that to assist the court's ruling. And I can set that, since it doesn't appear to require any additional testimony or similar, on August 5th. That's next Wednesday. And Ms. Van Haverbeek is free to appear by WebEx if she so desires. I can do that at 1:30.
I did also just want to request 7 days to file any motions based on the new charge that was filed yesterday.
That is reasonable. You may do so.
Thank you.
Thank you. I'm just going to make a note on that.
Okay.